Let me welcome everyone. I'm going to take a minute and let the audience get in from the waiting room, and then we'll get started. All right, I think we can go ahead. Welcome to On the Docket, looking ahead at the new Supreme Court term. This is an annual program jointly with the American Bar Association Division for Public Education and American University Washington College of Law. I'm Steve Wormiel. I'm a professor here at American University, and I'm your moderator and will be a panelist as well. Thanks to Kathy Hawk at the ABA Division for Public Education for her partnership in organizing today's program and for a number of years in the past, and to the conference and events director and staff at the Washington College of Law and the audiovisual staff at the Washington College of Law. To start us off today, it's my great pleasure to welcome Mary Smith. Mary is the president of the American Bar Association, the first Native American woman to hold that position. Mary is a former high-level official in the Justice Department and the White House. She's a former CEO and current board member of the Indian Health Service and current member of several health and housing industry boards. Mary is a longtime and wonderful leader in the American Bar Association. We are honored to have her, and Mary, thank you for being here.
Well, hello, everyone. It's my pleasure to welcome you to the 2023 On the Docket webinar to preview the 2023-2024 United States Supreme Court term. This program is the result of a long-standing partnership between American University Washington College of Law and the American Bar Association's Division of Public Education. And I'm pleased to note that this year's panel is also co-sponsored by the ABA section on civil rights and social justice. Studying the court, its recent and upcoming cases, and the overall direction of the court in American law and politics advances the mission of the ABA to help lawyers and the general public better understand the nation's highest court and its work. In recent years, the ABA has undertaken a number of projects to deepen awareness of the importance of the Supreme Court and shore up public trust in the judiciary, including the newly formed Task Force for American Democracy and also the Task Force on Law, Society, and the Judiciary, which released a report earlier this summer, noting that reactions to judicial decisions in cases with wide-reaching impact on the lives of Americans are often intertwined with larger societal debates. I hope that today's discussion allows us all to reflect on the court's recent decisions and the reactions to them, and provide us with the opportunity to consider the court's role in our democracy historically and in the future. I will leave it to our esteemed moderator, Professor Stephen Wormiel, a dear friend, to introduce each of today's guests. But first, a comment on Professor Wormiel, who has been a vital member of the ABA for many years. Professor Wormiel, in addition to being a professor of practice of law at American University Washington College of Law, is formerly a member of the ABA Board of Governors and a past chair of the section of Civil Rights and Social Justice. Steve, thank you so much for your ongoing partnership on the Docket and your commitment to educating law students, lawyers, and the public about the rule of law. Thank you so much.
Thank you, Mary. Thanks for the kind words and the inspiration, and we hope that your projects and goals for this year as president are going to bring great success and insight, and we wish you all the best. The new Supreme Court term begins on Monday, October 2nd. So far, a relatively small number of cases, 22, have been added to the court's schedule for oral argument. We're going to look back briefly at last term Then we're going to highlight some of those 22 cases that are already scheduled for oral argument. And then maybe talk about a few that are in the pipeline headed to the court, and then try to take some time to answer your questions. Please put your questions in the Q&A feature, not the chat, and we will be looking in the Q&A feature to try to see which ones we have time to answer, and get to as many as we can. Joining me today, and I'll give you brief intros. We've put longer intros in the chat. So joining me today, in the order in which you will hear from them, my colleague Leah Epperson, who's a professor here at American University Washington College of Law and a longtime experienced civil rights lawyer. Morgan Ratner is a partner in the Supreme Court and appellate practice of Sullivan and Cromwell. Spent a number of years as well in the Solicitor General's office. She has argued 9 cases in the Supreme Court and briefed hundreds. And we will just add that she's on parental leave and is kindly giving up some of that time to be able to join us today. So thank you, Morgan. Erwin Chemerinsky, my longtime friend, is the Dean of the University of California at Berkeley Law School. He's also argued cases in the Supreme Court, has written 16 books. I think it's probably more than that, but that's what his bio says, including leading law school case books in a variety of subjects. He's authored hundreds of law review articles and has long been a leader in legal education and one of the leading minds on constitutional issues, civil rights issues, criminal justice issues in the country. And Kimberly Atkins Storr is an opinion writer for the Boston Globe, a longtime commentator on the Supreme Court, a frequent guest on MSNBC, WBUR Radio in Boston, and many other news outlets. And she was also a trial and appellate lawyer before getting into the news business. So that's our crew today. I hope we'll have a lively and fun discussion. Leah, you're up first, and we hope you can just tell us a little bit about last term's affirmative action ruling, but maybe even more importantly, what's gone on since. Where are we? So thank you, Leah.
Sure, Steve, and thank you for having me. So yes, so one of the more famous pieces of the last Supreme Court term were the decisions of Students for Fair Admission versus Harvard and UNC, the 2 affirmative action cases. And so I can tell you just briefly what they were about, what they held and didn't hold, and maybe what they pretend for future litigation. So as many may know by now, the Supreme Court ruled on the legality of race-conscious admissions policies at a public university and private university. Public university being the University of North Carolina, and thus that case was examined under, or that policy examined under the 14th Amendment's Equal Protection Clause, and then the private university, Harvard University, their race-conscious admissions policy examined under Title VI of the Civil Rights Act of 1964, which of course prohibits racial discrimination by any entity that receives federal funding. And so the court struck down both policies as running afoul of the law. This was, many people believe, a sort of upending of more than 4 decades of precedent, given that in all prior decisions regarding the constitutionality of policies at University of California, Michigan, Texas, the court upheld race-conscious admissions policies if race was used as one of several factors, not a determinative factor, in a holistic admissions process, and that satisfied a high level of scrutiny. However, Chief Justice Roberts, in his opinion, struck down these policies and essentially stated 3 bases for this legal violation. One went to the notion of how the institution may measure the idea of diversity as a compelling government interest, and held that the policies lacked coherence and lacked sufficiently focused and measurable objectives, despite noting that diversity is a commendable goal. So more a question of how is it measured. Roberts held that the policies impermissibly employed race in a negative manner that he likened to racial stereotyping, and that the policies lacked meaningful endpoints. All things that seemed, again, to go against the grain of history, which is why you also had a very forceful dissenting opinion by Justice Jackson, where she said that the majority opinion defied law, history, logic, and justice. So the question coming out of that decision is, what may be permissible for colleges and universities in their ongoing admissions processes, and what does that portend for any consideration of race in spaces outside of a college admissions process? A couple of things to keep in mind that the court did leave in place, if you will. One is that the court stated clearly that universities have authority to establish their own missions as they see fit, and that universities may consider an applicant's experience and background associated with race. So there was a very sort of clear statement at the end, or maybe unclear, depending on how you look at it, in which Justice Roberts does make clear that colleges and universities are still able to find ways to sort of see the whole experience of an applicant, including their racial experience, and how these may contribute to a university community, or how race may affect their lives. So this last piece might also be a point in which we can talk about what might be coming down the pike in the wake of this decision. The decision was very clearly explicitly limited to college admissions processes. So this is not a decision that directly addressed scholarships, financial aid, outreach, recruitment, retention, pipeline programs, pathway programs, data collection, no discussion of race, well, I should say race neutral strategies were just identified as something that should be distinguished from ones that are race conscious, and the court held that those are not a part of this decision. No mention of or discussion of DEI programs, and the decision is not touching faculty or staff employment. So all of these things are not a part of the Supreme Court's ruling. But the implication of this decision is that there may be things coming down the pike in any or all of these areas. And also questions around the sort of four corners of what Justice Roberts discusses when he says an applicant should feel free to talk about their experiences in an essay or in an individualized fashion that has to do with race. So the questions going forward may really be about these areas. We do already know there is new litigation, both in the space of higher education, in the space of K-12 education that's somewhat affected, and even in terms of employment and other areas around recruitment. One well-known footnote that Chief Justice Roberts has in the majority opinion makes clear that the decision does not affect the admissions processes for our nation's military academies. Well, that's one of the first places for litigation. So SFFA is currently suing West Point in federal district court in New York. And the aim of that litigation is to eliminate all racial considerations in service academies admissions programs. So that was recently filed. That is coming in the wake of this footnote in the SFFA Supreme Court case that said military academies are not a part of the decision. And this goes to an argument that was made in prior case law that our nation's security depends on having a diverse officer corps. And it was something stressed by the Solicitor General in the oral arguments. So that is a decision, I mean, that is a space that is now in the space of litigation. We also have seen current litigation in places like SFFA has filed suit against UT Austin, despite the University of Texas Austin eliminating a very small race-conscious program in the wake of the Supreme Court decision. They are seeking to push race-blind admissions at that university. There's also litigation in the K-12 space, this question of what the Supreme Court has held with respect to higher education. Is it relevant to admissions policies for what may be prestigious, selective public magnet schools? So there is one in Alexandria, Virginia, Thomas Jefferson High School, which has what is by all accounts actually a race-neutral admissions policy. But there is an ongoing case, and plaintiffs have sought review of this policy after the Fourth Circuit held that the policy did not discriminate against Asian American applicants, but it is a lawsuit that is sort of similar and in the vein of what we've seen at the higher ed level. The other thing I think worth mentioning is, so again, we have litigation coming in the spaces that were not necessarily directly addressed by the Supreme Court, but these contours of exactly what it means to have diversity, how one seeks it, and what spaces are protected or not protected outside of college admissions. So there are also a few lawsuits currently looking at grant and fellowship programs designed by law firms and one by a venture capital fund that are designed to provide greater career opportunities to underrepresented minority groups. And those are being challenged by Ed Bloom, who is the chief challenger of the Harvard and UNC policies. And we shall see what happens with those. I know that with one of them, at least dealing with the venture capital fund, Fearless Fund, just this week, a federal district court judge denied a request for preliminary injunction to block this fund from considering applications for grants for businesses that were led by women of color. So that's another piece of ongoing litigation that is about the contours of what remains after the affirmative action decisions. And I'll stop there for now.
Thank you, Leah. Anyone else either want to add or make any observations about last term briefly?
Yeah, I'll say one thing, and it's great to be here, everyone. You know, I think that last term had obviously a lot of really interesting hot button issues, and the general narrative that many people talk about is a conservative supermajority at 6-3 court. I think one area where we didn't see things like that shake out is in some cases involving a limited federal government and implications for businesses. In particular, the court did not adopt a broad reading of well, it's hard to do a reading because it doesn't exist, but a broad construction of a dormant commerce clause. It did not adopt a sort of vigorous reading of the due process clause, in these cases, national pork producers and in Mallory. And in both cases, it let states do a lot more regulation and reached an outcome that a lot of people perceive as not that helpful for business. So in the overarching narratives of the court, I think that's a really interesting undercurrent that goes in the other direction.
I would make two comments, one procedural and one more substantive. The procedural is the Supreme Court last term was effectively overruling cases without explicitly saying it was doing so. The term before, in Dobbs overruling Roe versus Wade, in Kennedy overruling Lemon, the court said it was doing so. But what's interesting in the affirmative action case, there's no doubt the court effectively overruled Bakke, Grutter, and Fisher, but nowhere does Chief Justice Roberts' opinion say we're overruling the precedent. There was another instance involving Title VII and the obligation of employers to make accommodations for employees' religious beliefs. The court effectively overruled TWA versus Hardison from 1977. The court adopted a new standard in Groff versus Joy, but it didn't say that's what it was doing. The substantive comment, and I'll put this together with the term before, is how dramatically constitutional law has changed in a couple of years. Steve, you mentioned that I have a common law casebook. I did the first edition almost 30 years ago. I just finished the 7th edition. I've never seen a new edition where so much changed from the prior one or all of the prior ones. I mean, just think about the last 2 years. The court's overruled Roe versus Wade. The court's dramatically expanded gun rights. The court for the first time has said that a public school teacher has the right to pray at public school events. The court's imposed a dramatic new limit on federal administrative agencies. The court's effectively overruled the affirmative action cases. All of this in just the first time the Supreme Court said that businesses have the right to discriminate based on expressive activity in violation of state anti-discrimination laws. And this is just in 2 years. It really is, I think, dramatic when you put it all together.
All right, thank you. Anybody else? If not, we'll turn to the upcoming term. All right, so just a couple of quick observations. I haven't asked the panelists specifically to focus on this, but I will note that a disproportionately high number of the cases that we're about to talk about come from the U.S. Court of Appeals for the Fifth Circuit in New Orleans. The Fifth Circuit has become a very high-profile, maybe muscular would be a good term, appeals court, asserting itself on a number of issues at a national level, and quite a few of its cases are up for review in the Supreme Court. And then the other thing I'll just add is while we're about to talk about the cases again that the court has already agreed to hear, there will be additional cert grants, maybe later this week, maybe early next week. And so the docket, sometimes the case that a term starts out one way and then changes dramatically during the course of the term because the court adds additional important cases. That said, Morgan, you're going to tell us about some cases that have enormous potential to affect federal government power, and why don't you take it away?
Yes, thank you. So we talked about only 22 cases this term, but an awful lot of big ones for separation of powers and the administrative state in that relatively small group. I'll talk the most about one and then briefly touch on two others. So the big one I think most people are thinking of as the big one is Wilbur Bright Enterprises against Raimondo, where the court is considering the continued vitality of the Chevron doctrine. Most of you probably know this doctrine already, but for those of you who don't, Chevron is a deference doctrine that says if a statute is silent or ambiguous on a question, agencies that are empowered to construe that statute and apply that statute, their interpretation of it gets deference so long as it is a reasonable one. Chevron in the last decade or so has come under increasing fire by those concerned about the size of the administrative state. And frankly, at the Supreme Court, it's sort of faded away. That's not necessarily true in many lower courts, but at the Supreme Court, I can't think of a case in the last, 7-8 terms where they've cited Chevron, even in cases where it seems like it would be a really obvious fit or sort of an easier way to resolve the case. They've just gone on ahead and instead of worrying about deference, have decided the question on the merits. You can see that same attitude kind of paralleled in the government's briefs. What 15 years ago would have been a brief that says Chevron, 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 now kind of has a paragraph tucked at the end that says, well, if we're not right on the statute, at least it's reasonable and we win under Chevron. The question has in some practical sense in the Supreme Court faded, but like I said, it retains significant importance in some lower court decisions and probably in the practical world of what agencies feel like they are empowered to do under a statutory scheme. So here the scheme's kind of interesting. There's a federal agency that monitors fishing boats for compliance with federal regulations, operates under a scheme that says those boats need to carry a federal observer. But what the statute doesn't say is who pays the salary of that federal observer. And so the agency has said that the fishing boats pay for that, and the fishing boats have challenged that and have said, the statute doesn't authorize you to require us to pay. And to the extent that the agency is claiming Chevron deference for its conclusion that the operator should pay, well, Chevron should be overruled. We've seen petitions like this a lot over the last, like I said, decade even. What's really interesting about this one is, well, first that the court took it, and second that it took it and seemed clearly interested in grappling with the Chevron question. There was a statutory specific question presented in the petition, and then a question that said, should Chevron be overruled, or at least should it not apply in circumstances where the statute is silent? on an important issue. And the court took only that Chevron related question, a question about either overruling or narrowing Chevron. So unlike in some other petitions or other cases, we don't see the court trying to duck the question. We see it just taking that specific question. I think it's still, it's not certain that the court will have a decision directly saying we overrule or do not overrule Chevron. They certainly could still say, at the very least, Chevron deference should not apply, and there's no statutory term being construed or something like that. There's still room to maneuver there, but the court seems to want to be exploring what vitality, if any, Chevron has at this point. And it's an important separation of powers question on a couple dimensions. The traditional challenge to Chevron has been that it transfers power from Congress or from the legislature to the executive, to the administrative state. But the pushback, the flip side of that is there's also a separation of powers implication from getting rid of Chevron, which is it transfers power from the executive and the agencies to the courts. And so either way, we're going to have some sort of pretty considerable implications for the administrative state and for the separation of powers coming from that case. There are two other cases that involve the administrative state. I'll just mention more briefly, although frankly, we could do an hour and a half on either of these. One is the Consumer Financial Protection Bureau against Community Financial. That's a case that will be argued Tuesday, and it is challenging the funding scheme of the CFPB under the appropriations clause of the Constitution. So for Constitution nerds, not a clause that you see construed every day, and so kind of a fun one to see. The basic issue there is that the CFPB it doesn't get appropriations from a sort of yearly or biannual appropriations, but instead is funded through a mechanism where it can request funds from the Federal Reserve, basically in perpetuity, up to a particular limit. The challengers say, look, given all of the unique aspects of its funding scheme, that is not requiring Congress to appropriate the money. That's money that's not fairly construed as drawn by an appropriation. And the government responds like, look, we have a lot of agencies that do a little bit of this, a little bit of that. And if you add those characteristics together, that in and of itself shouldn't create an unconstitutionality here. And we'll see what the court does there and how it, if it's interested in questioning that scheme, maybe how it slices and dices it so that it doesn't bring a bunch of other agencies into question as well. The other case is the Securities and Exchange Commission against Charkhazy. In this case, there is a challenge to the SEC's ability to seek civil penalties in administrative proceedings. And the Fifth Circuit sort of said that was a no-go under just a host of reasons. The first is that administrative enforcement violates the Seventh Amendment right to a jury. The second is leaving the choice to an agency to elect between going to an administrative process and going to a court for an enforcement proceeding violates the non-delegation doctrine. And the third is that having these administrative cases heard by ALJs who have for-cause removal protection and are operating underneath an agency head with for-cause removal protection, that is a separation of powers violation. We've got, I don't know that the court is likely to find merit in all of those. Some of those would be pretty big decisions, but if it finds for the challengers on any one of them, there'll also be some pretty interesting remedial questions that will arise. And the administrative scheme, I think between these three cases, could have some serious limits, or it could have some kind of carefully tailored limits and some carefully written opinions that are meant to serve other administrative agencies. So we'll see what happens there.
All right, quite a load of federal power issues ahead. Anybody else want to add anything on those cases? All right, Erwin, we always seem to have a heavy docket of free speech cases and First Amendment cases, but this may be the term of social media at the Supreme Court.
I think so. There have been a handful of cases about the internet and social media since its inception. Many thought last term that the Twitter versus Tamna and Gonzalez versus Google would be important cases, but they were decided on very narrow grounds. There's two cases where review has been granted. There's another that's already before the court in a procedural matter, and there's cert petitions and two others that I predict are sure to be granted. So let me start with what's already been granted. Two cases that'll be heard on October 31st, O'Connor Radcliffe versus Garnier and Linke versus Freed. And they come with similar facts, though the circuits came to opposite conclusions. Michelle O'Connor Radcliffe is a member of a school board. She used Facebook and Twitter to communicate with the public. Some parents, Christopher and Kimberly Garnier, criticized O'Connor Radcliffe. And so O'Connor Radcliffe blocked these parents from continuing to have access to her Facebook and Twitter. The Garniers sued, saying this violated the First Amendment, and the United States Court of Appeals for the Ninth Circuit ruled in favor of the parents and against the school board member. The Ninth Circuit said that this is media that's being used to communicate to the public, to constituents, but matters with regard to government operation. This therefore should be regarded as state action, and it violates the First Amendment to block those who are criticizing the government office holder. The other case is in James Freed, the city manager of Port Huron, Michigan. Here, a constituent criticized him. Kevin Linke was his name, and Freed then blocked Linke from having access to Freed's social media. Linke sued, but the United States Court of Appeals to the Sixth Circuit came to the opposite conclusion. The Sixth Circuit said that this is private Facebook, Twitter. There's no state action, so the Constitution doesn't apply. If the issue sounds familiar, it's because people remember when Donald Trump was president, he tried to block some of his critics from having access to his Twitter feed. The courts ruled against Trump. By the time it come to the Supreme Court, he was no longer in office, so it was moot. So in one sense, it's a state action question. How do we regard the private social media accounts of these office holders? But it's really about a First Amendment question, because these are media that are used by the office holders to communicate about what they're doing in office, but matters of public concern. So pay attention to those, because I think they're going to be important. The second thing that I wanted to talk about is Biden versus Missouri. A federal district court issued a very broad injunction against the White House and many federal agencies from, quote, coercing or encouraging social media to remove false information. A few weeks ago, the United States Court of Appeals for the Fifth Circuit in large part affirmed, though also reversed some. Mostly the reversal was narrowing the federal agencies. So now it applies basically to the White House, to the FBI, to the Center for Disease Control, and it prevents them from, quote, coercing or encouraging removal of false information. It is worth focusing on what's the coercion here. The coercion is that the Biden administration allegedly threatened the social media platforms that if they didn't take this down, they'd be subject to more regulation in the future. Is that enough to be coercion? And the Fifth Circuit said that the government shouldn't be encouraging social media to take down false information. But when is encouraging an infringement of speech? I encourage my students to speak responsibly, to speak with civility. Is encouragement really enough for infringement? Justice Alito has stayed the Fifth Circuit order. There's some confusion over the status of that stay, but I predict the Supreme Court will stay what the Fifth Circuit has done and take up the issue, with the underlying question being, what's an infringement of the First Amendment? And I think the most important social media cases are two cert petitions. I think they're on the long conference list, so we'll hear later this week, early next week in all likelihood. It's Net Choice versus Attorney General of Florida and Net Choice versus Paxton. What's involved here are laws adopted in Florida and in Texas that prohibit social media platforms from engaging in content moderation and also require a great deal of disclosure by them. The United States Court of Appeals for the 11th Circuit, an opinion by Judge Newsom, struck down the Florida law. He said, social media platforms are private entities. They have the same ability to decide what to include as a newspaper or any broadcast station would. And he said that with regard to this requirement for prohibiting the content moderation, we want social media platforms to be engaging in content moderation. We want them to be taking down a lot of awful speech that wouldn't be unprotected by the First Amendment. On the other hand, the United States Court of Appeals for the Fifth Circuit upheld the Texas law. Judge Oldham wrote that opinion, and he wrote an opinion that also said that ultimately First Amendment freedom of speech should just be about a prohibition of prior restraints, and found that the Texas law was constitutional. The cert petitions came to the Supreme Court last spring, and I think surprising many, the Supreme Court asked for the views of the Solicitor General. Not sure why, given the split between the circuits, but the Solicitor General wrote a brief this summer urging the Supreme Court to take these cases. And there are so many state laws of varying kinds now regulating the internet. In conservative states, prohibiting content moderation. In liberal states, encouraging more content moderation. I think these cases are likely to be enormously important.
Sorry, I'm muted. Any questions or comments? All right, thanks, Erwin. Kim, you have two unrelated cases, one about standing to sue under the Americans with Disabilities Act, and one the fascinating OxyContin bankruptcy dispute.
Yes, both of these cases are really unrelated to each other, except in the fact that they both involved ways for groups to seek redress, classes of people who have been harmed to seek redress under two very different statutes. I'm going to apologize ahead of time, one for my cold, and two because there is street construction happening right outside, so it may be a little noisy, but we'll get through this. So the first case I want to talk to is called Atchison Hotels v. Lawfer, and there are a lot of unusual things about this case. One, it's a case involving the Americans with Disabilities Act, which the Supreme Court very rarely takes up. You don't see a lot of cases based on this. It's out of the First Circuit, which is very rare for the Supreme Court. And it also has a very unusual procedural posture that brought it to the US Supreme Court. It involves something called testers under the Americans with Disabilities Act. And Deborah Lawfer, the plaintiff in this case, is one of them. She looked at the website of a Maine hotel, and it didn't offer any information about what accommodations it would offer for people with disabilities. Now, under the ADA, it requires that that information be available any place where a hotel allows you to book, and it was not there. And so she filed suit. This is one of many suits that have been filed under her name because she is, as I said, a self-professed tester. The ADA is different from a lot of civil rights statutes in that it was written purposely to put enforcement in part in the hands of citizens. The reasons being that people with disabilities are in the best position to be able to see whether a public accommodation is giving adequate accommodations or not. And B, it would be impossible for the government to be able to monitor all the public accommodations across the country. So it made sense to allow private citizens to be able to bring suits in order to enforce the ADA. Most of these suits are aimed at making these accommodations change their practice, but there's also requests for things like attorney's fees. And if someone suffered some injury, you can also get civil damages as well. But that wasn't what was being alleged here. The hotel countered challenging Deborah Lawfer's standing, saying she lived in Florida, she's in a wheelchair, she had no plans to visit Maine, let alone that hotel. And so she didn't suffer any injury that is redressable. The district court agreed with the hotel, but the First Circuit reversed and found that it is not necessary to have standing in order to have suffered an injury because of that language in the statute that says it's the responsibility of the hotel to put this information on its website. Well, a couple things have happened before the argument in this case next week. One, the original lawyers for the plaintiff, one of them was brought up on some disciplinary action at his state bar for claims that he was bringing vexatious litigation. Essentially, he was bringing these ADA claims just to get attorney's fees. He wasn't really trying to bring change to these industries, and he is facing action at his state bar. The plaintiff actually sought to dismiss this case at the Supreme Court because she said she didn't want that to be a distraction for the important work that the ADA does, and she didn't want a negative blowback from that. The hotel opposed that, and the Supreme Court did not dismiss it. It will move forward. But whether or not this case is moot, both because of that and also because since then the hotel has put the information on its website saying that it actually is not, it cannot accommodate people with wheelchairs. That could be how the court rules if it doesn't want to get to the constitutional or the standing issue in this civil rights case. But what the standing issue could mean is that a key way that the ADA has been used to try to bring public accommodations into compliance with it could be taken out of the statute if they find that in order to bring a case, you actually have to have suffered some injury, meaning that you have to show that you wanted to visit, you had plans to visit this establishment and you had to change them and you suffered some injury. That would really eliminate a lot of the ability of people to enforce it. Also, if you're trying to deal with vexatious lawsuits, there are other ways to do it. State laws can change their rules in terms of how these lawsuits are brought, what attorneys can do. You can toughen sanctions for vexatious lawsuits that really have no merit and are just meant to be nuisance suits or trying to rack up attorney's fees, as is what's alleged by the plaintiff's original client. So there's a lot here. There's a lot of ways the Supreme Court could rule, but it could have broad implications. And another case that could have broad implications that I'll mention quickly that came up late on the court's docket is one that is called Harrington versus Purdue Pharma. I'm sure everyone is aware of OxyContin and over the past decade or more, the really horrific impact it has had through addictions. More than 250,000 people have died from OxyContin overdoses. Well, a very large settlement award in excess of $6 billion was reached through attorneys generals at various states, a lot of individuals, groups that help assist people with addiction issues. A very complex settlement was reached in bankruptcy court after Purdue Pharma filed for bankruptcy in this case. Well, one aspect of this case was that the Sackler family, which owned Purdue Pharma, certain members of the Sackler family, I want to be clear here because I don't want to be sent any letters from their attorneys, but certain members of the Sackler family, which own Purdue Pharma, were, as part of this bankruptcy proceeding, received clemency from facing future lawsuits. They were immune from facing future lawsuits based on these OxyContin deaths. It was about to be finalized. And then finally, the federal government stepped in and said, wait a minute, no, please do not finalize this settlement, because if people who are not parties to a bankruptcy suit, and keep in mind the families of the Sackler family that owns it is not part of the bankruptcy, is not the party in this case, Purdue Pharma is. But if non-parties are able to dismiss their liability through bankruptcy court, it would just open up a loophole for people who are wrongdoers to try to escape liability by doing it through a bankruptcy court. Bankruptcy courts weren't meant to do that. So the Supreme Court took the stay application, treated it as a cert application and grants it cert to answer the question whether the bankruptcy court authorizes, the bankruptcy code authorizes a court to approve as part of a Chapter 11 reorganization, the release that extinguishes claims held by non-debtors in a bankruptcy proceeding. That's going to be a big deal, not just because of the impact it can have in future bankruptcy deals and in settlements, but also what it means for mass tort litigation generally. That can often be handled in the meantime, as this case pens. Remember, all of these claims are being unpaid and the people who need this money are waiting for it. So it's a big case there.
Thank you so much, Kim. We appreciate it, and we're going to let you go off camera if you like, because I know you're not feeling well. And thank you for staying with us. We appreciate it. I'm going to briefly present a case about the Second Amendment. It is called U.S. versus Rahimi. As we all recall, in 2022, the Supreme Court ruled in New York State Rifle and Pistol Association versus Bruin. It struck down a New York State requirement that if you wanted to have a weapon concealed, carrying it outside the home, you had to try to justify, New York had to try to justify that its registration regulation by some historical analog. It had to show that practice would have been regulated at the time of the adoption of the Bill of Rights, or some comparable period. And that basically created a new standard. It was the first time the court had decided a Second Amendment case in about a decade. And the lower courts now are wrestling with what the court said in Bruin and how to apply it. So Rahimi is going to be the first example of that, and there will be others that will follow Rahimi. Zaki Rahimi has basically admitted, he lives in Texas, I believe, has basically admitted that he's a drug dealer and that he was involved in multiple shooting incidents in Arlington, Texas, in 2020 and 2021. Police at one point searched his home and found him in possession of a pistol and a shotgun. Also earlier in 2020, he had been subject to a domestic violence restraining order in the Texas state courts because he had assaulted his girlfriend. There is a federal statute that says if you are under a domestic violence restraining order, you may not legally own a weapon, a violation of federal law. The U.S. Court of Appeals for the Fifth Circuit, hearing Rahimi's argument, basically said that under Bruin, under the 2022 Supreme Court's decision, that the statute that prohibits gun ownership if you have a domestic violence restraining order was unconstitutional. The Fifth Circuit essentially said there's no historical analog for that kind of gun ownership having been prohibited or disallowed at the time of the founding of the Bill of Rights in 1789, or ratified in 1791, and that's what the court's Bruin decision meant, and therefore this was unconstitutional. The Solicitor General has appealed to the Supreme Court. The Supreme Court has agreed to hear the case. It'll be argued on November 7th. Rahimi basically sticks to his position and says it's unconstitutional. That's what the court meant in Bruin. The Solicitor General essentially says the right in the Second Amendment to keep and bear arms is a right for law-abiding, responsible individuals, not people who are abusing the law or abusing other people. And therefore, the court should reverse and say this is not consistent with what the court meant in Bruin. Again, this will not be the last. There's already a court decision striking down a similar federal provision that says if you're a convicted drug user, you may not possess a gun. Whether this decision will dispose of that case or whether that case will be the next one up to the Supreme Court will remain to be seen how the court decides this case. There's already numerous lawsuits about ghost guns, guns being made on 3D printers with no serial numbers and untraceable, and whether the restrictions against ghost guns are constitutional or not. So I think we're in for a wave of new Second Amendment rulings by the Supreme Court to define the dimensions of the Bruen case, and so stay tuned. Leah, voting rights never seems to leave the Supreme Court's docket. It was there last term. It's back again this term. Tell us what's going on.
That is correct, Steve. It does seem to be the gift that keeps on giving. So there's more voting rights to come this term. And, you know, in thinking about the trajectory of cases of the court, of what Erwin said about the, you know, sort of massive changes that have taken place when you're thinking about teaching constitutional law over the last several years, this is an area where you could kind of put it with the affirmative action cases earlier, where we know that over the past decade, there have been major blows in the court to the 1965 Voting Rights Act. With 2013 with Shelby County versus Holder, after that with Bronovich. And then, you know, last term, we had a couple of decisions in Allen versus Milligan and Moore versus Harper, which seemed to be for some a bit of a departure from what we're talking about with Dobbs and with SFFA. And that was one in which the court, I guess you could say, reinforced that there were some things that were still protected, if you will. Milligan with voter protections like those in Section 2 of the Voting Rights Act, that those were constitutional, and that states could depart from the federal framework when crafting their own voting rights. And then you had Moore, which was looking at the critical role that state courts play in protecting the right to vote. So after those opinions, you know, fast forward to this term, we have yet another voting rights challenge before the court, this time in the state of South Carolina. So the court will hear an appeal to a ruling. The case is Alexander versus the South Carolina Conference of the NAACP. And it's a ruling that ordered South Carolina to redraw its congressional map because the state's first congressional district was found to discriminate against Black voters on the basis of race. The background is that last year, the state had adopted a congressional map in which state map makers ended up moving hundreds of thousands of South Carolinians to other congressional districts. And the end result of that was that the district's Black populations in all but one of those districts was low enough that Black voters would not have an equal opportunity to elect a candidate of choice. And so essentially reducing their electoral influence in 6 of the 7 districts. So and of course, plaintiffs were challenging this, highlighting that what the legislature had done was to sort Black voters on the basis of race without a compelling reason to do so, and engineering the map in order to dilute Black voting power. So a unanimous federal 3-judge panel in January ordered South Carolina to redraw that 2022 map. And this was after an 8-day trial. They found that the legislature did impose a racial target in a particular congressional district, Congressional District 1. And that was the district where there were tens of thousands of Black Charlestonians that had been excised. So the court found that this had the effect of essentially abandoning redistricting principles, and they called it a bleaching of Black voters from their former district. So plaintiffs are now advocating for the implementation of a lawful map in time for the 2024 election cycle. And like I said, this is a case that will be heard on appeal to the court. So we shall see what happens. It's also maybe worth noting that this is as we see more cases like this, Steve, when you're saying that they seem to always show up at the court, this is perhaps also a bit of a reason why we might see a movement for legislation at the state level. There's more of a movement now around state voting rights acts that might fill the gap in certain voting rights that some believe have been lost as a result of Shelby County and Bronovich. So that's just something to keep in mind as well.
Steve, can I add one thing quick on this?
Sure, please.
I think that it will be interesting, and Professor Epperson, you may have views on this, it will be interesting to me to see what happens in terms of challenges to state decisions in the wake of the Moore decision that Professor Epperson mentioned. The court there, it did not adopt the broadest version of what people call the independent state legislature doctrine, but it did leave open a path that I think it really has long been associated with Chief Justice Rehnquist's concurrence in Bush against Gore for a federal court reviewing the state court decision to see whether the court was being court-like. I think I've just pulled up the sentence. The critical sentence that struck me from that opinion is state courts may not transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. And that's, arguably new. And I think it will be interesting to see as we head toward a new election cycle, whether there are kind of a whole new world of challenges that try to say that state courts are acting improperly under that standard. We haven't seen a lot of that yet. And I'll be curious to see whether that happens next.
So not on the grand scale of last term's independent legislature theory, but more on a state by state basis.
On a decision by decision, this decision was not, the court was not acting like a judiciary. This decision, the court was really acting like a legislature. And so the federal court needs to step in because, the reading the court adopted was such an atextual reading of such and such states regulations or something like that. I expect that that's just a new class of litigation that we'll see soon.
All right. Leah, what anything we should say about the courts denying the stay in Alabama this week? Does that tell us anything longer term, or is that just the court saying what part of our prior decision did you, Alabama, not understand?
Yeah, sort of reinforcement of their earlier ruling in Milligan. I mean, it's an interesting question. I mean, they are affirming what was said before and kind of going back and saying, do we need to say it more clearly? You need to draw a remedial map with the second opportunity district to ensure that Black voters have the representation they deserve. So it was very clear and it was sort of made without comment. But I often think of what Arwen mentioned earlier, that this was, in this particular term, you do have instances of the Supreme Court making sweeping changes without necessarily explicitly stating that they are overturning precedent. And so when you're asking about sort of what the long-term implications for something like this may be, I think it remains to be seen, because I do think we have examples of, I mean, even if you think back to Shelby County, it wasn't as though that was a complete decimation of the entire 65 Voting Rights Act, but it was such a significant gutting with this particular section of the Voting Rights Act that it did have long-term sweeping changes. And given that we have that history, I'm not entirely sure of what will come next. I don't think, and so Morgan, I appreciate your point. It's not as though I think suddenly now we're in this era where we have a Supreme Court that is a robustly and fully embracing all aspects of the Voting Rights Act. I think there's some things that we've seen marginally in terms of vote alignment that has tried to carve out pieces and been more thoughtful and nuanced, but I'm not really sure that is going to be a trend that continues, or this is just what's happening right now.
What I would add is in Allen versus Milligan, the Alabama voting case, The Supreme Court affirmed the three-judge court, and it was a 5-4 decision. Justice Kavanaugh was one of those 5, and he wrote a concurring opinion which said, perhaps we should reconsider the constitutionality of Section 2 in light of the changed circumstances, the same way that in Shelby County versus Holder, the court found that preclearance was no longer necessary because of changed circumstances. So the fact that one of the 5 in the majority has said, maybe it's time to reconsider the constitutionality of Section 2 certainly raises flags for the kinds of cases that are going to come to the Supreme Court in this coming election cycle.
Thank you, Erwin. I think I'd like to turn there's some questions in the Q&A, but I think before we get to them, or maybe as we move forward, I would love to just mention a few issues that seem almost certain to be added to the court's docket in the coming days, weeks, months. I guess one of the first ones is the mifepristone case. Anybody in particular want to talk about that, or I'm happy to do it? Erwin, Morgan. Erwin, you want to go ahead?
The case Alliance for Hippocratic Medicine versus Food and Drug Administration, a very conservative district court judge in Texas invalidated the FDA's approval of mifepristone, which is one of 2 drugs that's usually taken for medically induced abortions. The United States Court of Appeals for the Fifth Circuit found that as to the invalidation of the approval, it would stay the judge's decision, but it would allow the judge's decision to go into effect with regard to certain Biden administration policies that made it easier to have access to mifepristone. During the Trump administration, in order to have mifepristone, it would have to be taken in a doctor's office. The Biden administration relaxed that. That's certainly important in terms of things like telemedicine and ability to get mifepristone in states where abortion is illegal. The Supreme Court stays the Fifth Circuit decision, saying that mifepristone will remain available as it is now until the Supreme Court either denies cert or grants cert and denies the merits. The Fifth Circuit then hears the merits of the case, and it comes to the same conclusion it did earlier when the stay was before it. It said that the FDA's approval of mifepristone will not be overturned, but the FDA's changing the policies that made it easier to access would be enjoined. And now it's all before the United States Supreme Court. I think it's worth putting it in the context of this. The district court decision here was the first time in history that any court had stopped the approval of a drug that was approved by the FDA. And in terms of the requirement that mifepristone be taken at a doctor's office for all of the drugs that exist on the market, this is the only one that the FDA had ever said has to be taken in the doctor's office. And so it's clear, I think, that both the district court and the Fifth Circuit decisions have to be understood in the context of courts that are conservative and quite hostile to abortion rights. And then it's coming to a court that just overruled Roe versus Wade.
All right, so that's one case, and I think the court certainly, is there any doubt that the court has to take that? I don't think so. I'm going to pull one out of the Q&A because, Erwin, I know it's something you wanted to mention as something coming up as well. There's a question saying some legal scholars say the Supreme Court should rule quickly on the 14th Amendment insurrection issue, Section 3 of the 14th Amendment, involving Trump. Would or should the court take it if the appeals get there? So, Erwin, I think you had wanted to talk about that issue.
Just real briefly, lawsuits have been filed in some states, Colorado, California, arguing that Donald Trump is ineligible to serve on the ballot. Section 3 of the 14th Amendment says that somebody who took an oath of office and then participated in rebellion or insurrection can't again hold office. I think that it's going to be a bit of time before these cases can make their way to the Supreme Court, but I agree with those who have said it would be desirable for the Supreme Court to resolve this issue earlier rather than later. The nightmare scenario is imagine that it's Trump versus Biden, and imagine after the election, or even in the midst of the summer before the election, there's a challenge to whether Trump is eligible to serve. And so it's an issue of constitutional law. Is Trump eligible under Section 3 of the 14th Amendment? There's no Supreme Court precedents that can be used to help guide this. and yet it's of such enormous importance if we decided sooner rather than later.
I'll just add one thing on that. You know, there is a standing issue. We talked about standing before. A lot of the questions in the chat that maybe we'll address some more have been about standing. And so I think for an issue like that to speed its way to the court is going to have, you know, threshold issues on standing that we'll see whether courts resolve in the same way, and whether the Supreme Court wants to take it out when it has a potentially easy out on a ground like that.
Could we also find ourselves in a situation where the court applies its too close to the election doctrine and says we're not going to decide that issue? I don't know if that's a I mean, it's an existing doctrine that some of the justices seem very fond of. It might seem bizarre to apply it to something that fundamental, but maybe. Any other cases in the pipeline that we want to mention before we turn to the Q&A? I don't know whether, I mean, there are some January 6th related cert petitions. I don't know whether there's anything that is really pressing for the court to take up right away, or whether that's something that will take a little more time. I'm not thinking of anything else, or when you covered the social media cases that we think the court will, the net choice cases will certainly have to take. So, all right, if we don't have any other pipeline cases, I will invite my colleagues to open the Q&A, and let's see what we can do. Erwin, you had indicated that you wanted to tackle the first question, and I think Leah might want to weigh in as well.
Actually, I was trying to type a response and hit the wrong button, which just shows my incompetence at doing this. All I would say is that what the Supreme Court had held in Bakke and Grutter and Fisher is that race could be used as one of many factors in admission to benefit minorities and enhance diversity. I regard the court's decision in Students for Admission versus Harvard College is overturning that and saying no longer can race be used as a factor to give a benefit to minorities. As Leah pointed out, at the end of his opinion, Chief Justice Roberts said, but in considering an individual applicant, then it's permissible to look at the role of race in that person's life, and he said, such as overcoming discrimination or inspiration. That's going to be a hard line for admissions committees to draw and for courts to draw with regard to review. With regard to the question that came in the chat, in the Q&A, I think it's important to look at states that eliminated affirmative action by voter initiative and seeing their impact and thinking about what's going to be the impact of the Supreme Court decision. Justice Sotomayor, in her dissent in Students for Admission, says it's likely to be, quote, and her word was devastating. California voters in 1996 eliminated affirmative action in Prop 209. The number of Black and Latinx freshmen fell by over 50%. It took UCLA over 19 years to get to its pre-1996 levels of diversity for undergraduates. As Justice Sotomayor pointed out in dissent, Berkeley hadn't gotten back to its pre-1996 level of diversity as recently as 2019. So that's why I think this decision could have a real effect in response to the question.
Leah, do you want to add anything, or?
I would just, I mean, I would have said basically what Erwin said. I do think that for better or worse, we do have these examples of what has happened with the removal, and it is a confluence of factors. So when the ability to consider race as one of many factors is removed, but proxies of privilege remain, you continue to have even a more sort of skewed student body, if you will. So when you're talking about what happened in California after Prop 209 and this dramatic falling of Black and Latino students, it was particularly strongly felt at the most prestigious institutions in the state, so the flagship institutions, so a UCLA or Berkeley. And the time that it took to kind of figure out how to craft policies that were able to view admissions more holistically, you didn't see a kind of going back to pre-209 levels at UCLA or Berkeley. There was a movement, but it was in other parts of the state institutions. So I think one thing to think about, and what I might not have mentioned in the upcoming cases is even what some of the challenges are to these proxies of privilege. So for instance, shortly after the decision, a complaint against Harvard for legacy admissions. And so when I'm talking about the proxies of privilege and how that then affects admissions, I'm thinking of things like legacy admissions, preferences for children of major donors. When we look at the impact of standardized test scores and the reality of who has access to the training and the classes to be able to take the things that will get your highest SAT score or LSAT score, those are also proxies for privilege. And when those remain in place, it creates an even further barrier for the kind of racial diversity that we're talking about. And none of those so far have been removed.
All right, there's another question that says, speaking of race, would the recent decision on admissions lead to the elimination of diversity programs in the workforce? And what would that mean for those who were hired based on diversity?
Well, so that's when I was saying earlier, Steve, that nothing in this opinion is about employment. Nothing in the opinion is about diversity, equity, and inclusion initiatives in employment spaces. So, and this is, I think, a part of it where it's important to think about how people lead, the importance of leading with facts and not fear. So there's nothing in the opinions about diversity in hiring and employment. However, in the wake of the decision, I think what you have found are a number of spaces conjecturing and having questions and fears in the, in those spaces as well. And so that's why I mentioned there are lawsuits that are not related to the Supreme Court's decision that, only dealt with college admissions processes, but ones that are challenging grant programs and fellowship programs. And again, the Supreme Court decision was about the constitutionality under the Equal Protection Clause of the 14th Amendment for a public university's admissions process and a private university's admissions process under Title VI of the '64 Civil Rights Act, which is aimed at those private entities that receive federal funding that might be discriminating. And so it was not a Title VII issue, it's not an employment issue. I think one of the interesting things is that the very laws that were used to essentially overturn the spirit of Bakke and Grutter are still in place as the ones that are used for the real legal imperative we have to address histories of a denial of access and opportunity in education and employment, meaning that is the genesis of Title VI, it's the genesis of Title VII with respect to employment, and those do still exist. So I think it's important from the perspective of looking at employment and employers to not flip the other way in terms of looking at the landscape of access and ensuring that those pathways are open and spaces are open in fields that have historically been prohibited for people of color.
I will
completely
just add on. Oh, sorry, go ahead.
Please, Morgan, go ahead.
Just to add on to that, I think the reason though why, I work for a law firm, my clients are a lot of big businesses, and the reason why those companies have concerns is that there is similar language between Title VI and Title VII of the Civil Rights Act. And you have, just for those who may not have picked that up, Title VI prohibits discrimination in the entities that receive federal funds, and Title VII in employment by employers of a certain size. You have different strands of Supreme Court precedent on those two different provisions, but you also have, for example, a concurrence by Justice Gorsuch in the recent affirmative action decision that says, like, hey, these two things get interpreted in the same way because it's effectively the same language. And so if you're part of the business community and you're looking at that and sort of thinking about your risks, one of the things that you have to weigh is the possibility that the court's going to say, well, look, that's the same language. We're going to transplant whatever we've said in the higher education context into that employment context as well. And so then a lot of these questions are, what would that mean? What should we do to minimize that risk? And that, I think, is where some of the concern is coming from.
Two things.
Absolutely, and that makes sense. And I think the only caveat I'd give is when we're talking about, you know, the notion and employment of DEIA, of diversity, equity, inclusion, and accessibility practices and programs, they're designed to reduce barriers for workers and to promote equity, you know, in the workplace. And many of these programs are designed to expand applicant pools and not ones where we're looking at a specific decision-making process where race is used, which was the factor that was identified in the college admissions processes. So I think also there's a lot of space in there in terms of what we talk about around considerations of race broadly, around expansion and recruitment and things like that.
I was going to say two things. One to note is that the Supreme Court doesn't endorse the view that the Constitution requires that there be colorblindness. Justice Thomas says this in his concurring opinion in Students for Admission, but it's notably absent from Chief Justice Roberts' majority opinion. And in Allen versus Milligan, the voting case we were talking about, Justice Thomas again took the position the Constitution requires the government always be colorblind, and Chief Justice Roberts rejects that there. That could have implications for the employment context. The other thing I say is keep in mind that the Supreme Court's last two decisions about affirmative action employment of Title 7 were a long time ago. It was Steelworkers versus Weber in 1979 and Johnson versus Santa Clara in 1987, both opinions written by Justice Brennan. Court was very different then than now. And I think that also explains why some of the concern that Morgan is expressing is there in light of the change in the composition of the court, and in light of what the court did in the Harvard College case.
All right, Morgan, there's a question here for you about if Chevron goes away, what takes its place?
Yeah, so there's a simple answer, and then I just want to give the slightly more interesting one. You know, Chevron is a doctrine of deference, right? It's saying, okay, well, maybe that we don't have to decide if we had to decide, does the agency have the better reading of the statute or not? Instead, a court gets to say, like, look, there's sort of a range of reasonable readings, and you're in it, and good enough, and we can call it a day. So if Chevron is overturned, there's not really a doctrine that's substituted. It's just well, now the court has to decide what it thinks is the best reading of the statute. But this sort of twist on that I just wanted to mention is in the last couple terms, we've seen the emergence of the major questions doctrine. And for those who, like me, who litigate a lot in the commercial space, we see this invoked quite often now by litigants. And that's almost in certain cases, it's almost the reverse Chevron. It's, well, maybe you're in the range of reasonable things, but the statute isn't crystal clear. And in that case, the agency cannot act if the court deciding the case thinks that the issue is sort of big enough that Congress needs to be crystal clear on it. So I would have said, if you get rid of Chevron, you move to a world where it's just everybody, you know, when the issue goes to a judge has to decide this is the best reading of the text. But I do think now we're in a world where, you know, that's true unless the issue is really big. And in that case, it's not just the best reading of the text, it's also the, you know, super crystal clear reading of the text if the agency is going to have power there.
Right. I'm going to combine two questions. There's a question that says, why is it obvious that there was a standing problem in 303 Creative if the courts didn't address it? And there's another question that says more broadly, since we're talking about standing so much, can we speak to how the court uses the doctrine to get rid of cases it doesn't want to decide and to decide cases where it's willing to ignore the standing doctrine? So maybe we can combine those. Anybody want to speak to that?
In terms of 303 Creative, it was really more a rightness question than a standing question. Lori Smith says, I have a business that designs websites. I want to expand it to design websites for weddings, but I don't want to have to design websites for same-sex weddings. Colorado law says, as a business establishment, I can't discriminate on the basis of race, sex, religion, sexual orientation. She says, federal court, give me a declaratory judgment that I can violate this law, with regard to not designing websites for same-sex weddings without any consequences. That, in other words, give me a declaratory judgment that I have a First Amendment right to not design websites for same-sex weddings. That's a classic ripeness issue, and generally people don't have to violate a law in order to challenge it. You don't have to eat a mushroom to know whether it's poisonous or not in the eyes of the Supreme Court, but you do have to show that it's likely to be applied to you in the future. And the way Lori Smith did this was an affidavit where she said, I received a letter from somebody who wanted me to design a website for a same-sex wedding. After the case was decided, turned out that the affidavit was fictitious. The man who was identified was already married to a woman. He had never written to Lori Smith. And so this then raised the question of, well, was the foundation that she had used to show it was likely applied to her fictitious and therefore shouldn't have been a basis for standing? But I don't think as a matter of the application of the standing doctrine, when the Supreme Court decided the case, it was questionable. It's just a shame that the false nature of the affidavit didn't come out earlier. I think the Supreme Court is following the same rules of standing it always has. Article 3 requires injury, causation, redressability. But I always think there's been a dimension of the court using standing sometimes to duck cases it doesn't want to reach and not finding Article 3 problems when it wants to decide the case. To go to Morgan's example, I think that Moore versus Harper, Justice Thomas had a compelling argument that the case was moot because the decision of the North Carolina Supreme Court had always been overruled. But I think the Supreme Court wanted to reach the merits of the independent state legislature here in a relatively low stakes controversy rather than wait till after a presidential election when it came back in the context of a state's awarding of electors in the Electoral College. So I do think there was a manipulation to speak of justiciability, but I think that's always gone on with the court.
There's a question here I'm not sure anybody can answer, but can anybody sue the Biden administration over the current immigration crisis? And what do we do about the people that have been bused illegally to New York and other places? There are certainly a large number of Republican state attorneys general who believe they can sue the Biden administration over the current immigration crisis. Whether they're right about their standing or not is an interesting question, but there are such lawsuits going on. Anyone else on that question?
I guess I'd just say one thing quickly, which is, the court cut back or, didn't extend, depending on your view, state standing to challenge immigration decisions just last term in the United States against Texas case, where Texas and Louisiana wanted to challenge immigration enforcement guidelines, and the court said, no, we're not going to allow you to do that just because you're a state that has some number of immigrants in it and some number of potentially undocumented persons. And so, that case, had it gone the other way, I think we would have seen a lot of state suits on pretty much every policy. I don't know that the reverse is true, that, because the state didn't have standing there, that states are going to just lie down and never sue over complicit policies anymore. But I think that may have stemmed the tide a little bit.
Right. There is one member of the audience who is not particularly satisfied with the answers about affirmative action in higher education and seems to think that it's not consistent to say that race was just one factor, and yet when race is no longer allowed to be a factor, that it's having a significant impact on diversity. I thank the member of the audience for the comments. I think our panelists have made their views clear. I think you have made your views clear, and I appreciate your voicing them. There is a question about the military and the West Point case. Will the Supreme Court's affirmative action decision maybe come out differently in the West Point case because there's more data about the need for and value of diversity in the military? including in the Supreme Court's own decision. So might that be a different outcome? Any thoughts on that? Nobody want-
Oh, sorry. I'll
No,
let
go ahead.
somebody else start if they want.
No, go ahead, please.
I mean, I think that Steve, you sort of hit the nail on the head when you said the piece about military academies that was key is that this was a part of the Grutter decision. This, you know, a piece that was key that O'Connor picked up on was really voiced in the amicus brief that was filed by a number of former Joint Chiefs of Staff and high-ranking military officials that talked about the idea that when students of all races and backgrounds are in college together and live together and learn together, there's something that is better in terms of citizenship and leadership, and that this is also vitally important to the nation's military because the military academies is where we draw from where we draw our officer corps. And they talked about the history of this with respect to Vietnam War and the lack of diversity in the officer corps and what that did for morale and for sort of the strength of national security. So it was cited by O'Connor. It was raised quite a bit by the Solicitor General in oral argument. And I think the court's way of dealing with that, rather than effectively overturning that this would have no impact on national security, they note that diversity is indeed a commendable goal, but there's no, in their view, institutional competence by which to measure the success of it. And then they put a little footnote to say nothing in this opinion is meant to affect military academies. So that's the sort of way they get around this, the arguments that were made by the Solicitor General around service academies as this example of a place where we see the benefits of diversity. I'm not quite sure that the distinctive nature of military academies is what would distinguish it in terms of a different Supreme Court decision. I thought, in my view, and others should join in, that was just the court's way of not dealing with that particular thread. They just put it in a footnote and said, okay, we're not going to touch it. I don't know if Erwin or Morgan, you.
Anyone want to add? Go ahead, Erwin.
The only way I can see the Supreme Court drawing a distinction is about deference to the military, because there is such a history in constitutional law of deference to the military. But it's hard to explain why, for all other college universities, race can't be used in admissions, but for the military academy, it's different. Justice Jackson made that point in her dissent very powerfully, saying, so we'll allow affirmative action when it benefits the government, but not when it benefits diversity in the boardroom. Her exact words were something like that.
Erwin, I'm going to close with one for you. Somebody's asking, will the Supreme Court overrule Kelo? The Ikander decision, cert petition was denied in 2021, and several justices indicated that they should hear the case and that Kelo was wrong. You think we're going to see a revisiting of Kelo?
There's no doubt that Kelo wouldn't be decided the same way today. It goes to what's public use under the takings clause, and the Supreme Court saying it's public use so long as the public would benefit from what the government is doing. Keep in mind that virtually every state adopted a law to essentially nullify Kelo within their states. So the Supreme Court overruling Kelo would have an effect with regard to constitutional law, but much less of a practical effect than you might think.
All right, we are out of time, and I would love to thank our panelists for a wonderful, interesting, informative conversation. I would again like to thank the American Bar Association Division for Public Education and the American University Washington College of Law for facilitating this, and thank you all for joining us. We are finished. Thank you, everybody.
Thank you.
Thank you.